Madam Secretary, there are many and serious problems with respect to immigrant detention. I want to focus on the repeated transfers of detainees between ICE facilities. According to a June 2011 report by Human Rights Watch, there are about 2 million detainee transfers between 1998 and 2010, often over long distances that required the use of airplanes. Almost half of all detainees were moved at least twice. These transfers lead to inefficient removal hearings and cost $366 million in transportation alone, facts that should concern my friends on the other side of the aisle, among others. And the problems seem to be growing. Transfers tripled between 2004 and 2009. Now, moving detainees away from where they live impedes their ability to retain counsel, often on a pro bono basis. Since they are often moved when their removal hearings are already underway, the entire process bogs down. And detainees lose access to evidence as well as friends and family, which makes it difficult to show to a court in a bond hearing that they are not a flight risk. And this results sometimes in unnecessary and costly detention. Now, DHS and ICE seem to recognize that a transfer policy needs reform. In August of 2009, ICE Director Morton announced a series of changes, including the creation of an Office of Detention Policy and Planning to revise transfer policy. In October 2009, Special Advisor to ICE Dora Schirro recommended that detainees who are represented by counsel should not be transferred outside the area unless there are exigent health or safety reasons, and when this occurs, the attorney should be notified promptly. In July of last year, ICE adopted an online locator system so counsel, friends, and family could at least locate detainees. Despite these steps, however, there still has not been a comprehensive change to detainee transfer policy. Now my questions. Madam Secretary, do you agree that we need a change to policies which lead to the repeated transfer of detainees so that we can finally protect their due process rights and improve the efficiency of our immigration courts?
Representative Nadler, there are a number of reasons why we want to limit transfers of detainees. The cost, efficiency, access to counsel, access to family members. The practical problem we confront is that we don't always have detention beds where we have detainees, and that causes there to be movement. One of the things we're doing through our Office of Detention Policy is trying to contract for more beds in some of our higher intensity areas so that we can limit the number of movement among our detainees.
Do you have any estimate of when the new policies to appropriately limit the transfers will be in place?
Well, it is our policy now to limit transfers. I think the question really is, when will we have contracts for more beds, and as soon as we can get them, we will get them.
So until you have contracts for more beds, you cannot really limit transfers?
Well, we limit them as much as we can.
Do budget cuts negatively impact your ability to adopt a more humane and cost-effective transfer policy?
The Congress gives us a certain amount of money. We have to operate as efficiently as possible within the scope of that appropriation. We cannot remove 10 million people from this country. We have to make choices. We have to prioritize. But in that conjunction, yes, if we don't have the money to move, and if, more importantly, the Justice Department, the marshals, everybody else involved in the system doesn't have the ability to manage that, it is a problem.
Thank you. Among many problems relating to these transfers, one that struck me was the impact it has on detainees' ability to be represented by counsel. A recent June report from Human Rights Watch says, and I quote, "Attorneys with decades of experience told us that they had not once received prior notice from ICE of an impending transfer. ICE often relies on detainees themselves to notify attorneys, but the transfers arise suddenly and detainees are routinely prevented from or otherwise unable to make the necessary call. As a result, attorneys have to search the online detainee locator for their clients' new locations. Once a transferred client is found, the challenges inherent in conducting legal representation across thousands of miles can completely sever the attorney-client relationship. This is especially true when the same person is transferred repeatedly." That's the quote. Now, this is all very problematic, obviously. Can you commit to me and to the committee that you will take whatever the steps necessary to try to reduce significantly detainee transfers far away from counsel? In other words, the locations of counsel should be one of the major, should be a determinant in who gets transferred or where. Can this be a part of ICE's new policy on detainee transfers?
I think it should be one of the factors taken into account. And I do think, you know, the fact that we now have a locator when we didn't have one before, it sounds like a simple thing, but given the number of people who run through the immigration system in a given year, it was a difficult IT thing to get done because it's a fast-moving system. But that will help counsel as well.
And would you agree that it would be a better practice and policy to at least notify counsel when his or her client has been transferred, not make them look around on the online system?
Well, I think to the extent possible, we should do that.
The Chairman's time has expired.
Thank you.